Welcome the viewers over the world. This is the legal prophet, the Gum Bakeri's candidate. Of course, without wasting time, we are going to look at we are going to continue with episode 2 of the law or of the tort of negligence. And in episode 2, we are basically going to talk about the duty of care. Of course, I told you that the tort of negligence, for you that read between the lines, started developing in the year 1883, but of course it developed in 1932. That is in the case of Donald versus Stevenson, where we see Lord Atkin giving the leading judgment, and he told us that for there to be the tort of negligence, 1, there must be 3 elements. That is duty of care, 2, breach of duty of care, and 3, damages caused by breach of care. Now, the tort of negligence as a tort, we are going to look at the duty of care in depth or in detail. So, the duty of care is the first ingredient or is the first element of the tort of negligence. And the duty of care did not develop at once. No. It also has 3 ingredients, meaning that should they tell you that talk about the duty of care as known in the tort of negligence, you should know that it developed in 3 stages, or it has 3 ingredients. And these ingredients, they developed in 3 separate years. The first ingredient of the duty of care developed in 1932. The second ingredient developed in the year 1978. And then the last ingredient of the law or of the element of duty of care developed in 1990. So, the first ingredient of the law, of the element of duty of care in negligence, is known as reasonable foreseeability. That reasonable foreseeability developed in the case of Donald versus Stevenson. Simple. And it is what was termed as the neighbor principle, where we see Lord Atkin had to define who a neighbor-in-law is, where he said that a neighbor-in-law is not that someone who is just near to you. Your neighbor-in-law can even be thousands of miles. But a neighbor-in-law is that someone who is likely to suffer harm or damage as a result of your act. That's why you see, he had to say that no, even if the person who bought the ginger beer was another and gave it to another person, that other person who took the ginger beer was a neighbor. Why? Because the people who manufacture products, they should know that indeed, even if actually they manufacture products but they don't know who will consume them, so they have to exercise a reasonable duty of care to ensure that whoever will ever take their drink does not suffer damage. So, the first ingredient of the law or of the duty of care is the ingredient of reasonable foreseeability, that the mere fact that you foresee that your act is likely to injure someone, then restrain from it. Whether it's your neighbor, closeness or proximity, or no. That is the first ingredient. It stems out from, or it comes from, what we know as the neighbor principle. Now, at first, from 1932, wherever they had to prove duty of care, they only had to prove the ingredient of foreseeability and the neighbor principle only. But later, we see that the second ingredient came into play. And that ingredient, some of the people can say the 2-part test of negligence. When they talk about the 2-part test of negligence, they don't mean that, oh, what does that mean? When you see the 2-part test, you can either call it the Ann's test. When they say the 2-part test, it means that now, in the year 1978, that is when we see the second ingredient of the second ingredient of duty of care developed, which we are later going to know, or we are going to know as proximity. So proximity as an ingredient of the tort of negligence developed in the year 1978. So the reason why it is called the two-part test is based on the fact that until when we went to the year 1978, they now applied the two tests. That is the first one, which is reasonable foreseeability, also known as the neighbor principle, or it was and proximity. So the reason why it's also called the Ann's test, it is because it was developed in the case of Ann's versus Merton LBC. That is Merton Law Barrow Council. So Ann's versus Merton Barrow Council in the year 1978. And to be specific, like we saw that the person that introduced the tort of negligence as a tort, and the person who introduced the ingredient of foreseeability was Lord Atkin. Also, the judge that introduced the second test of negligence, also known as the Ann's test or the two-part test of negligence, was known as Lord Wilberforce. Lord Wilberforce. So, Lord Wilberforce introduced the two-part test or the test of proximity. Basically, look at that case of Ann's. It was a case that involved the London Borough Council or the Merton London Borough Council, which had approved a flat, like plans or building plans of a flat, which when constructed, of course they did it properly, inspect it, and later, after I think 1 year of occupation, it developed cracks, and on developing cracks, later it caused damage to the tenants. So what the tenants did, they went and sued instead of the builders. They sued the council that approved the plan for negligence. So the issue of proximity had to come into where they had to conclude that no, the person should not be just close to you. Proximity can come in situation of if there is damage to be caused, you are the next in line. I might be driving a car along the highway, but the person who is proximate to me is the road user, either a border guy, it can either be a pedestrian. Those are the people within my proximity. I might not know them, but the mere fact that they are within the degree of closeness, that should I be negligent, should I fail to exercise a reasonable care, those are the people that are likely to suffer. So, regardless of whether the council constructed or no, the people who are proximate to its act were even the tenants. So, court had to come in and say, no, here even the council could be held liable. So, of course, with time, different cases had to come in discussing the issue of proximity, and meaning that from the year 1978, all cases that involve duty of care, they now have applied two tests. That is reasonable foreseeability, also now known as the neighbor principle, and the proximity. Then it's later until where now there are situations where now things were unfair. That's when we see that the third test, which we also know as the three-part test. When I say the three-part test, I mean that now, from this time round, they applied 3 tests of duty of care. The three-part test. If you cannot call it the three-part test, you can call it the Caparo test. So the three-part test or the Caparo test came in the year 1990. It came in the year 1990. Of course, it developed in the case of Caparo versus Dickman. In the case of Caparo versus Dickman. So the case of Caparo versus Dickman, 1990, the leading judge or the lead judge or the person that gave or introduced the concept of the three-part test is known as Lord Bridge. So you have to know Lord Bridge. Lord Bridge of Lord Bridge. So Lord Bridge had to lay the foundation of the three-part test. And Lord Bridge introduced the concept of reasonable, fair, and just. Of course, reasonable, fair, and just is the third element of the tort of negligence, that is in the element of duty of care. So, reasonable, just, and fairness came in as a defense to the defendants or to the tortfeasors, because now many people were facing prosecution, but now they had to come in to revise with coming up with the reasonable, just, and fairness. So that third test in the law or in the ingredients of duty of care came in to protect the defendant. So the question is, what was in Kaparo and Dickman? So Kaparo wanted to buy certain shares, I think, from a company known as basically Kaparo Industries. It was a group of industries, and they wanted to purchase, I think, shares from a company known as Fidelity. Now, what they did, there was a guy known as Dickman. Of course, he was an auditor who had made reports or audit reports for Fidelity. And in his findings to him, he saw that the company was doing well. Dickman and Kaparo did not know each other. So what Kaparo did, Kaparo Industries, when they were purchasing the shares, or they were purchasing what they were purchasing from Fidelity, they based their decision on the reports that were made by Dickman, which later they proved that they were totally wrong. So instead of suing Fidelity or anyone, they had to go into, or they had to introduce, they had to sue Dickman. Why did he mislead? So court had to come in. That is, of course, a Lord Bridge arguing and saying that no, it's not just, it's not fair, it's not reasonable for you or for us to hold Dickman liable, who did not even have a contractual obligation with you. So when you rely on his statements, really, there was no duty whatsoever, because when he made these reports, he did not think that they would be relied upon by a third party. So court had to deny the claim of duty of care or negligence based on the just, fair, and reasonable. So as of today, from 1990 up to today, that is 2025, they have never added any ingredient on the 3 ingredients that were laid. Meaning that, what are we doing? It is our duty to think and introduce concepts and also say, no, the Bomboka test, the 4-part test, I come up with a test and say, no, let us add on to this. But I think jurisprudence stopped developing. So up to now, we have never had any ingredient added on when we talk of duty of care. So as of today, the duty of care was introduced in the case of Donald Stevenson, that is the neighbor principle, which now we know as the reasonable foreseeability. Later it grew in 1978, that is in the case of the Anns versus Martin London Borough Council, which is also referred to as the 2-part test or the Anns test, which introduced the ingredient of proximity. And later we see in 1990 where we see the 3-part test or the third test, also known as the Kaparo test, which introduced the issue of proximity. Of course, those are the ingredients of the duty of care. So should they tell you to talk about duty of care, never talk about anything, and don't talk about those cases and the principles. We meet in the next episode, of course, where we are going to talk about the second ingredient of duty of care. I mean the second ingredient of the tort of negligence, which shall be breach of care. Thank you for being viewers or good viewers. Don't forget, of course, to subscribe, like, and comment. We meet in the next episode. Bye-bye.